Good morning. My name is Loretta Vanegas. Buenos dias. I work at EPA Region 9 in San Francisco. It's my first day attending the training this week, so I'm hoping that you've had a good week learning from all my different colleagues and folks. So thank you again, and this is actually a short commute for me today, so I thank Terry for that. I live out here in the Valley, but I go to San Francisco 3 times a week, so this was great. I've been working with EPA for about 20 plus years in the Tribal Water Office in the Water Division. And our office is sort of like a one-stop shop where tribes that want to implement their Clean Water Act programs, they can apply through our office. So just kind of giving you a little bit of background. So we have different clean water tribal grants. And each program, the 106, the 319, requires TAAs, as some people may call it, treatment as a state. But for today, I'll be focusing on the water quality standards TAAs for tribal waters. Okay, so applying for TAAs under the Clean Water Act Section 303 and 401. Under the Clean Water Act Section 518E, this is what authorizes tribes to implement programs under EPA for their reservation. Under Clean Water Act 303C, it's the Water Quality Standards Program that you've been hearing this week, and it protects the surface waters or waters of the U.S. The tribes may apply for EPA Water Quality Standards, a TAS, that's the first step. And the TAS for Water Quality Standards approval process is similar, as I was saying earlier, to the Clean Water Act 319, which is our non-point source program, and the 106, which is the Water Quality Pollution program. The basic requirements for applying for TAS is the tribe must be federally recognized, have a governing body carrying out substantial governmental duties, have appropriate authority to regulate the waters of the reservation, and be capable of carrying out the functions of an effective water quality standards program. So sometimes the tribes have already implemented their Clean Water Act programs through our office, and under the 106 or GAP, the General Assistance Program from EPA, they can apply to establish this application package. So they can use the funding to establish this TAS. What does it mean for a tribe to receive TAS? Under 303, they can administer their water quality standards program. They develop their own standards, taking public comment on them and adopting them under the law. Submitting the standards to EPA for approval. They can interpret the standards to assist EPA's development and enforcement on discharge permits, and reviewing and taking public comment on their standards at least every 3 years as they revise their standards as appropriate. If they change, they would need to revise. What does it mean to receive TAS for Section 401? When the TAS comes into our office, the tribe can apply just for TAS and also implement under Section 401. And this authority would allow the tribe to certify permits for activities that discharge to the reservation waters. Federal permits and licenses such as NPDES, Section 404 permits. For right now, I understand the tribes do come to us. If they don't have this authority, then EPA is responsible for writing these permits. Does TAS for Section 303C and 401 give a tribe enforcement authority? No, EPA's approval will not impose any direct enforceable requirements on any party. Once approved, the standards can serve as a basis for actions such as effluent limits and permits, which are enforceable. This is sort of like a step of how we review the TAS applications that come into our office. First of all, the tribe submits their application. In our region, we have 148 tribes that we work with. And the first step, as I was saying, is the tribe submits the application. Then there's a comment period, EPA reviews, and then we have the final decision. And once approved, the EPA, a tribe generally has the same water quality standards authority and responsibilities as a state. For our procedures on reviewing the applications for Section 303 and 401, the tribe submits the application. So we have initial discussions. When the tribe is interested in submitting a TAS under 401 and 303, we meet with the tribe and explain to them the process. They submit a draft application to the region. So in our office, we have different project officers, and just depending on the project officer for that specific tribe, the TAS application comes in and we start the review process. So at first we call it's a draft application. We'll hold a conference call with the tribe just to make sure that if there's anything missing within their application, we discuss it, if there's additional information that we need from them. The tribe, again, if there's anything missing, then supplemental information can be submitted. And then we establish an official public docket. Our review, again, just more additional on our procedures of reviewing. There's a comment period where we need to notify appropriate governmental entities, or AGEs. And this is the 30-day public comment period. So we do publish a public notice within the local newspaper, just letting folks know that there's this TAS application that came in for the tribe. Public has 30 days to comment on the TAS application. We do notify appropriate governmental entities, such as, let's say there's a contiguous tribe next, or there's federal lands, folks that we would have to notify. We notify the state of which the tribe is located in, and the tribe has opportunity to respond to comments as well. As part of the EPA review, our team reviews the applications and the comments. If there's any comments that come in, sometimes we don't have any comments on the TAS, and we may request, just depending on the comments, we may request additional information from the tribe in order to respond to that comment. Once we have a final package and we feel comfortable in moving forward with that package, then, and all the comments have been received, we do the final review within the agency, and then we send it on to our headquarters. Our headquarters, Office of General Counsel is involved. Other offices within our headquarters as well review the application. And once all comments have been addressed and it's final, then the last step would be that our regional administrator makes that final decision and approves this package. Any questions so far? Yes.
Is there anything in particular out of the notification period that you would be interested in hearing from the states?
What I've heard from the states, like let's say with the state of California, it's normally we do send a letter to the governor, and then it's to the state board, and it's been more of supporting the TAS application and just making sure as we're reviewing the water quality standards that the regulations and everything are being addressed. So the process, once you have the TAS, so the TAS is just the authority for the program, it's authorization. It's not approval of the tribal water quality standards. The standards, draft standards do come in with the TAS application, but that's, the TAS has to be approved prior to the standards being approved. So the process for development of the tribal water quality standards is reviewing state standards. Sometimes the tribes do have their own tribal standards that have been approved by council. They must hold a public hearing on the proposed standards, and there's a minimum 45-day advance notice to the public and interested and affected parties. So this process is completed by a different office. Dave spoke earlier, so we work in coordination with Dave. Once we receive a TAS package, we work with Dave as far as, and his colleagues as far as reviewing the standards. Let's see, a document's available at least 30 days in advance and submitted standards within the 30 days of adopting to EPA for approval. So, and that can be flexible. I know that that's our goal. Okay, let's see. Why adopt Clean Water Act effective water quality standards? Provide protection of designated water uses. Provide legal basis to protect your waters that may be impacted from uses upstream of reservation land. Provide tools to improve the water quality where it is already degraded. And the three main components are the designated uses, criteria, and anti-degradation. Designated uses is protection of wildlife and fish, can include fishing, hunting, gathering activities, recreation. Sometimes we do see examples of each tribe has their own traditional and cultural uses, so that would be included in their standards as part of their standards. Examples of unique designated uses is, again, protection of wild rice, frogging, air boating. Human health criteria is just an example of what sort of a human health criteria would be. Fish consumption rate and EPA's recommended criteria. The national default for general populations is 22 grams per day. Default for substance fisheries is 142 grams. So all of this is included as far as in their standards because the tribes do rely on fishing, tribal subsistence for fishing. So they just want to make sure that everything is included within their standards. More examples of the human health criteria for fish consumption rate. Anti-degradation policies. Anti-degradation requirements provide a framework for maintaining and protecting water quality that has already been achieved, including 3 tiers of maintenance and protection. The highest tier of protection for outstanding national resource waters. Okay, now going back to TAS, this kind of threw me off because of, so we were talking about TAS, so that going back to the TAS process again, the tribe wants to demonstrate tribal capacity and ensures that the waters are fishable and swimmable for everyone, including tribal members. The TAS provides EPA recognition of tribes' water quality standards under the 303. And once established, the EPA and the tribe's water quality standards would serve as a basis, the limits permit. So once you have their standards, then the tribes can use that for their water resources. The benefits of TAS, it provides the tribe a mechanism to require conditions for discharges to reservation waters. With an approved TAS for water quality standards in 401, tribes review proposed federal permits and licenses for activities that can result in discharges and comply with water quality standards and other tribal laws. Tribes can either certify their discharges, comply, or certify with conditions, deny certification, or waive. This is sort of just a layout, a plan of how the development of the standards are. First tier would be the development. The second is the submittal of it, and then the last would be what EPA's action would be as far as approving. In Region 9, we have, I believe it's 18 tribes that have TAS. We recently have approved a couple more. There's Go Shoot that was just approved a couple of months ago, and that tribe is located in Nevada. So these tribes have their TAS for Water Quality Standards Program. And these tribes, about 9, have already approved water quality standards. So some of the other tribes half of the other tribes that don't have their standards are either in the process of being reviewed or developing the standards. So the TAS must be approved first again and then follow through with your standards. These are just some tools and resources for water quality standards information. The TAS application. There's a model, a water quality standards template model that tribes can use as far as starting their standards, and the human health criteria calculator. These are the type of grants that I was mentioning early on that our office does provide to the tribes. The 106 program is normally the general assistance program that develops the environmental office. And then tribes, as they mature in their environmental programs, can apply for different medias. So Clean Water Act 106 is their water quality pollution control, which establishes their water quality monitoring program. And 319 is their non-point source pollutant program. This is baselines, water quality standards. I don't know. Dave, do you have any more information on the baseline, if there's an update on that? No? Okay.
You know, other than we proposed to have the baseline out, and
Okay.
I don't think that it ever went final.
Okay. All right.
But you might want to explain what the baseline water quality standards for reservations.
That's what I would want you to do.
Okay. So there's lots of tribes across the country, and not all of them have TAS, and not all of them have water quality standards. So the idea was to use a floor of baseline water quality standards that would apply everywhere. There were a couple of options that were proposed, just apply them everywhere as it defaults to all tribes across the country. One was sort of a, hey, these are here, if you want them, you can use them kind of option. And there was another option that was sort of in between that I'm completely forgetting right now. Yeah.
Terry, has EPA considered using state standards, or did they in the past? Because I've seen EPA issue 401 certs for tribal land, projects on tribal land with a federal permit, and I have no idea what they're certifying it's complying with. State standards? Imaginary standards?
The latter.
I don't know.
From
Maybe
what
we
I
can talk about
understand,
offline.
the tribes can adopt the state standards, and if they want to make it more restrictive, they can. So it's.
But in this case, the tribe doesn't have treatment as a state, so they haven't adopted any standards.
Yeah. We can follow up with you. Good question. So this is tribal treaty rights and water quality standards. Maybe my attorney colleagues can help me with this section. Let's see. Just tribal treaty rights relating to natural resources may be affected by the state water quality standards. The Constitution defines the treaties as part of supreme law of the land. Clean Water Act Section 511 provides that information shall not be construed as affecting or impairing the provisions of any treaty of the United States, and the federal trust responsibility that we have with the reservations. Well, I guess we have questions. Let's see.
Loretta?
Yes.
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 Another question, just following up on what Catherine just mentioned.
Following up on what Catherine just mentioned, so it sounds like there could be a situation where a tribe has a more stringent standard than the state. How does that actually work out?
Well, what I understand, I don't know if Dave, you can jump in. I know that the tribes can have a more stringent standard than the states. So how would that apply?
If you guys remember, early on, Manjali talked about the Oklahoma versus Arkansas case that went all the way to the Supreme Court, and it was basically about downstream uses. There was one state that had more stringent standards than the other state. They were upstream. The one with the less stringent standards was upstream, and it affected the downstream. And so it went all the way to the Supreme Court, and basically the decision was that, the state upstream needed to ensure that the water quality at the border was meeting the other state standard. So that's the downstream protection. So the same thing applies for tribes, right? If a tribe has a really, really low number, and you have a water body in your state, and some discharge that's in there that's sort of going to flow through or near the tribe that has water quality standards, you need to make sure that your water quality standards are not affecting the standards of benefit uses and the anti-degradation procedures in that state. I do okay?
Yeah, thanks.
All right.
And can you talk about the flip of that? If the state standard is more stringent and the tribe is upstream, I mean, do they have to, that point that, I'm sorry.
It's just a reverse of the scenario you were just talking about, where the state was upstream and impacting the tribal water that may have a more stringent water quality standard. What about the reverse?
It's the same thing, right? Downstream uses. So if I understand your question, right, so, the situation I explained was a state flowing into a tribe, and you're saying, if there's a tribe flowing into a state, it's the same thing applies. It's downstream use.
So could the state enforce that? Or how does that work?
We need lawyers.
Questions are from the lawyers.
Exactly.
Another question from another lawyer. So tribes aren't stuck with Porter Cologne constraints, and so there's some liberties there, perhaps some freedoms there. Do they develop implementation programs to control the discharges, and how are those made? How is that a rulemaking and enforceable? Or do they just do standards without implementation?
They can do a number of things, right? So Loretta talked about, TAAs, then the standards, right? So once they have the standards, they can influence folks that are discharging into them. They can develop 319 programs, and they can develop permit programs. So, a lot of tribes have casinos and they have treatment plants, and so those things can be also permitted by the tribe. I think I'm answering your question.
Question, they would need to get additional delegation from EPA to be their own NPDES issuing authority, correct?
That is correct.
Yes.
And also, what about groundwater? I mean, do they develop standards for groundwater, or are we talking about just surface water?
Well, in this course, we're talking about surface water.
Okay, but could they go beyond? I mean, I guess maybe that's outside the scope, but.
I don't know.
Surface waters.
So if,
Under the Clean Water Act, it would have to be.
Right.
Is it safe?
So groundwater is not a water of the U.S. They're not required to develop water quality standards.
Yes, but I'm just curious if you've seen tribes try and also regulate groundwater, if the standards are solely, I mean, because in California we have standards for groundwater too, obviously under Porter Cologne, which is what. Oh, I was just going to say, I'm very aware that groundwater is not a water of the U.S., but I'm just curious whether, maybe piggybacking on Stacy's question, whether tribes were also looking at groundwater. That's in the standards anyone's seen developed. Anyways.
So I have a non-attorney question. So if we were going to try to just figure out what these tribes are up to, do you have a website that just tracks all this information? So if we wanted to just get the jurisdictional boundary of the areas where they've developed standards, that's easy to find?
Yes, and I can get that for you. It's not part of the slide, but each time we do an approval of a TAS, it is posted on our website for our headquarters program. Yeah.
So on enforcement, I think So no tribes have the permitting, NPDES permitting authority. So for example, like I've just worked on the Navajo expansion TAS, and there are systems that have federal permits because it's on tribal land, but we have incorporated before the TAS got approved, we incorporated their water quality standards that were approved for the rest of the Navajo reservation into the permit. So I think we would enforce, because it's in their NPDES permit, so we have the enforcement authority because they don't have that authority, but they are the ones that created the standards. I don't know if that helps. But I didn't answer your groundwater question. It's just surface waters, that's all. And then there's also, you can get the ability to get Safe Drinking Water Act TAS as well, and UIC, underground injection. So that's under the Safe Drinking Water Act, not Clean Water Act. And Navajo is the only tribe that has Safe Drinking Water Act TAS in the nation.
Thank you. So we have a few review questions at the end. Which of the following is not a requirement for a tribe applying to administer the Water Quality Standards Program? Any guesses? A? A? General? A? Okay. It was B. There was a new reinterpretation rule in May of 2016, so documentation of a tribe's own inherent regulatory authority, so that was changed back in recently in 2016. Yeah, so that was. Review question number 2, true or false? Tribal application for water quality standards program should include a listing of surface waters for which water quality standards will be proposed. True or false? True. Yes, thank you. The application must include the map, a very detailed map, a descriptive statement, the water sources that the tribe is planning on implementing their standards and approving the TAS application for. Next question, true or false again? A tribe must have managed comparable programs before it is eligible to administer a water quality standards program? False, yes. EPA looks for indications that the tribe is capable of administering a water quality standards program. This could mean the tribe has participated in programs that were administered by EPA or other federal agencies and not by the tribe itself. I have one more. Another true or false. A state that is affected when a tribe obtains the authority to administer water quality standards program can overturn the decision that granted the authority. Just talked about that, so good timing. False. Although EPA solicits comments from the state and others, only EPA can make the decision to grant or deny a tribe's application for water quality standards program. No, and there was one more. Where can tribes be authorized to establish water quality standards? Any guesses? E? E, all of the above. Tribes can be authorized through the TAS process to establish standards only for reservation areas, including those mentioned. Okay.
So Loretta, can you explain to the group what fee lands are and what allotments are? Yeah.
Well, that usually comes in. Thank you, Terry. Let's see. Fee lands. So this usually comes in through our TAS applications where tribes want to establish TAS and standards for their reservations, and sometimes they have fee lands, which are non-tribal trust lands, if I understand it correctly. I'm looking at my attorney here.
Well, I think fee is basically, you know, it kind of goes, like someone has property on the reservation. So the reservation is like the boundaries of the formal reservation, but there may be like individuals who have fee lands, which is like a legal term, you know, for, they get to keep it, you know, in perpetuity. And, but they can get the TAS that includes the fee land, so it's not taken out. It used to be, you know, she just talked about like this new interpretation of the statute, where when we did a TAS review, we used to have to go through this Montana test, which is a case that talked about kind of like, you had to kind of show the impacts to the tribe, so it was a lot more challenging to approve the TASs. But now we've basically just said, if it's on the tribal, you know, reservation land, then that's included. You don't have to go through and show that they meet the Montana test. So it's made it a lot easier to do the approvals.
Mm-hmm.
I don't know anything about allotments, so.
This private land.
Yeah, it's private land, right.
State, we were not including private lands. And
Right, there wouldn't,
private lands.
there's no
No,
state,
not see the water to that.
it wouldn't be state, it would just be like, oh, okay.
I think fee lands are, somebody individually owns it outright. Allotments were issued by BIA, and there's certain requirements that they go to descendants of the owners, so you can have a lot of family members at the end of the day own allotments, but they're still, I think, registered with BIA. And then trust lands are held in trust for the reservation, and you have to go through BIA and often the Indian tribe you never own them outright. You can essentially lease them. So they're just different forms of possession.
I mean, we receive TAS applications sometimes that don't have any fee land, so those are like more simple.
Right.
You know, we just show the reservation boundary. For the ones that you're describing, we actually do have the tribe go back to BIA to make sure, you know, to show us the title, because all of that would be the title status of those allotments, just to make their application more solid. Yeah.
So I don't know if this is
For any questions?
essentially my question would be, so if a tribe is claiming like ancestral land that isn't on their territory per se, that they would not be able to apply water quality standards to that, like to a water body that's on like an ancestral territory that isn't part of their current territory, if I'm wording that somewhat clearly? Does that make sense?
That's not part of the reservation?
Correct.
I'm not.
I think it says, well, at least with the multiple choice, it said only tribal trust lands not located within the boundaries would be subject to the water quality standards. So if it's not already recognized, is that what you're saying, that there's a new claim to ancestral land?
Yeah, I think what I'm thinking of is a tribe conducting like immersion ceremonies at a specific water body that may not be on their territory, their reservation per se. Could they include that in their application, so to speak, for water quality standards? Does that make sense?
Yeah.
I think if they can tie it back to somehow, if it's an informal type reservation,
I'm not sure. I'm just trying to come across the situation.
yeah, I'm not sure. I'm just thinking if it's an informal type reservation and the tribe has, you know, like you were saying, uses for that surface water, then if somehow we can include it in the TAS application, we would just have to work. And that's why each application is so different. And we work closely with our attorneys to answer those type of questions.
So it is something that could potentially be
I'm thinking that
included.
it can, yeah.
Thank you.
Was there a specific tribe or?
No, not exactly. I don't know all the particulars of it, so I don't want to kind of speak to it specifically, but I do have one that I'm thinking of in mind up in Northern California, Northern California, but I'm not sure if, what all the kind of land allotments are for maybe improperly using that word as well.
I mean, we have a lot of pending TAS applications right now, and we are working with a lot of the Northern California tribes. So the Hoopa Valley has their standards. That was one of the first TAS applications that we approved. UROC has a pending application that we're working with, and then Karuk and Quartz Valley. So the Karuk and Quartz Valley, Karuk is a very specific case where they actually do have an informal reservation, and we are trying to include that as part of their, so that's why I was thinking if that's what your question was. And again, it just depends on the tribe. Yeah.
What is an informal reservation?
Well, going back to the ancestral lands, so at one point it was part of the reservation, but through laws or treaties or something, it was, I don't want to say taken away.
I'm sorry, it used to be a reservation, or it used to be ancestral lands? Because my understanding is that reservations tend to be much smaller than ancestral lands, right?
Yeah, so it used to be an ancestral land, I would say. Yeah, I mean, we just due to the time, I can talk to you more about it after, because I was showing that example, and that's an example that we're working through right now. Thank you, everybody.